Today, we are starting with the subject of gerrymandering, the first of these programs. Many of you might remember that Hedrick Smith, when he addressed this group in 2016, warned us that gerrymandering was the #1 problem that compromised the fair election system. Since then, we have seen court cases in many states disputing the role that partisan gerrymandering has played in the outcome of elections. Today, we have an attorney and grassroots activist, Peter Earle, who is here to describe the role this plays in elections and to tell us about his successful court case against the state of Wisconsin, which will result in a Supreme Court decision later on this year. Mr. Earle's legal work focuses on the areas of civil rights, employment discrimination, lead poisoning, product liability, and redistricting. As an attorney, Mr. Earle has been selected for the AV Preeminent rating by Martindale-Hubbell in 2007. He was presented the William Gorin Rice Civil Libertarian of the Year Award by the American Civil Liberties Union of Wisconsin, and in 2014, Public Justice awarded him and his co-counsel the Trial Lawyer of the Year Award for winning a $1.15 billion verdict against former manufacturers of lead paint in California. Wow. Yay. Please welcome Peter Earle.
Thank you, Jane, and thank you, Dan, for the kind invitation to have an opportunity to speak with you here today. I also want to thank Toby and Barbara King, who put me in touch with them and made these arrangements possible. As Jane said, I'm now semi-retired. I moved out here from Wisconsin 2.5 years ago with my wife, Sandy. We moved to Lummi Island, and we moved out here because my wife obstetrician, wanted to take a job as a hospitalist here. She wanted to leave her private practice and be able to work more regular hours, but still wanted to deliver babies. She loves to bring babies into this world. And there you go. Can you hear me better now? Oh, there you go. So we came to Lummi Island, and the only thing I regret is that we didn't come 20 or 30 years ago. What's that? The beauty of this area is astounding. And we get up every morning and we pinch ourselves. Anyways, after my talk today, I hope that you will get a better understanding of the following: what gerrymandering is, what the legal context is in which it occurs, and the sausage making of how it's done, and where I think it's going legally in light of our little trip to the Supreme Court and some of the newer developments since then, and what it means if I'm wrong in my optimism. You know, I'm an optimistic person, so I have to have faith that things will work. So first I want to introduce you to the 9 of my 12 plaintiffs, the Whitford plaintiffs. The man in the white shirt standing three from the left in the back row is Bill Whitford. He's a retired contract law professor from the University of Wisconsin. He owns a home on Shaw Island and frequents this area with some regularity. He's a very smart man and was very involved in the formulation of this case. This case evolved in a complex way, and I will be describing that to you in some detail. All of those folks are Democrats. And the reason we had to have Democrats as plaintiffs is they had to have standing. They had to be the injured victims of the constitutional wrong we are asserting. Otherwise, we couldn't bring the claim. But in the process of bringing this claim, we spent a considerable amount of time and effort, all of us, including the plaintiffs, the legal team, and our supporters, in making sure that everybody understood we want a bipartisan solution. We are not fighting the Republican gerrymander in Wisconsin so that we can replace it with a Democratic gerrymander. We want to have a fair system. And that's what this whole process is about. So, let's go to gerrymandering. Okay. Partisan gerrymandering is a problem. It takes power from the people and gives it to self-interested legislators. It operates like a cancer on our democracy, impairing the representative effectiveness with which our political system works. Egregious gerrymanders decrease the likelihood that legislative decisions will reflect the will of the voters who participate in elections, and most significantly, it entrenches a party in power without regard to whether it receives a majority of the votes. Now, I want to explain this a little bit here. To understand gerrymandering, what you have to understand, you begin with the concept of the United States Census, which happens every 10 years. And after that census, it is constitutionally mandated that legislative districts, both federal and state, be reapportioned. And the reason that districts need to be reapportioned is to make sure that the populations of those districts are equal. And there's a little bit of a difference between federal districts for Congress and state districts for state legislatures, state senators, and state assembly people, and so forth. The difference is that the United States Constitution mandates that congressional districts be as equally apportioned as is practicable, which means there can be no population deviation in the size of the district at all, period. Any deviation is out of bounds, right? But state legislative districts have a little leeway. They can have up to 10% deviation, which is ridiculous because you don't usually see a deviation of that size. But most legislative processes try to keep the districts as equal as possible. Now, during this process, and this is a political process, some politicians try to feather their nest. They try to take advantage of the process and create job security for themselves. And that is not necessarily unconstitutional. That's just simple political activity. We've got to remember that we live in a tripartite system of law. We have the legislative branch, we have the executive branch, and we have the judicial branch. The legislative branch and the executive branch are political branches. What they do is political. The judicial branch is not political. It is supposed to apply and interpret the law, right? So, so what you often will hear judges say, I'm a judge, I don't make the law, I just simply interpret it and apply it. So when the legislature passes a law, and let's say that law is a very stupid law, all right? And your representative voted for that very stupid law. Well, your recourse is to vote that person out of office and replace him or her with someone who won't pass stupid laws, right? So this is very basic, and that works really well. And the courts, when asked to interpret a stupid law and asked to declare it, unconstitutional because it's arbitrary and capricious or something, the courts will defer to the legislature and say, look, wait a second. That you have political recourse. We have what's called minimum scrutiny. We will only see if there's a rational basis for the law, and we won't go further than that. We'll just leave it at that. Right? But sometimes the political process can't cure itself. There is no resort to that process at all. And when that happens, well, the courts have to intervene. You may be familiar, many of you may be familiar. I don't know how many, do we have any attorneys in the room? I think we have some. Couple, okay. Not too many. Oh, that's good. But you know, there's a thing called strict scrutiny that the courts use, and so whenever you have, for example, a minority, let's say African Americans, right, or Hispanics, and this minority group becomes the victim of invidious discrimination that has a foundation in the prejudices of the population at large, the majoritarian population. So let's go back to the days of Jim Crow in the South, right? And the courts and political deference doesn't work there. The victims of the invidious discrimination in the Jim Crow laws could not resort to the political process to cure the unconstitutional or the evil, insidious discrimination that they faced. They have to, their only recourse is to go to the court and say, court, fix this. The Constitution gives us equal protection under the law. The Constitution guarantees us substantive due process rights. The Constitution, you know, and so forth, right? So that is where this idea that the courts can intervene and overturn and not defer to the legislature. They treat those kinds of laws with strict scrutiny. They will interpret them very harshly in favor with a I guess if there's I wouldn't want to use the word bias, but with a deference to the rights of the affected minority, okay, which is appropriate. All right, now, strict scrutiny applies when you have a suspect classification, an invidious classification, like African Americans, homosexuals. There's any number of classifications that come into that rubric. Strict scrutiny also applies when you have laws that impair fundamental rights, right? Now, political gerrymandering doesn't fit easily into these ideas here, right? Because political gerrymandering, partisan gerrymandering, like I said at the beginning here, you have politicians feathering their own nests. So it's redistricting time. The county board, the city council, the state legislature meets to reapportion, and a politician says, well, if I move a couple of precincts over this way, I'll get some more favorable voters for me, and I can give these problematic people to this other guy over there, you know, and they feather their nests. Now, that is not unconstitutional. That is part and parcel of the partisan process that that redistricting is. So it's still gerrymandering in the sense that we have this, and I'll show you a slide in a second about that, but it's not, it doesn't cross the line into an egregious subordination of the adherents of the other party. Okay, we'll get into a little bit more of that, but I just want to lay that out there so you understand the legal framework we're going to be dealing with here. Here, the original gerrymander. All right, there was this was 1812, and the Massachusetts governor, Elbridge Gerry, signed a redistricting plan that strongly favored his party, the Democratic Republican Party, over the Federalist Party, and by creating a district that supposedly looked like a salamander. So the Boston Gazette, this is a reprint of a cartoon that was published in the Boston Gazette on March 26 of 1812. And that newspaper coined the word gerrymander using Governor Gerry's last name and the last two syllables of the word salamander, put those two together, and we have gerrymander. Now, huh? So I mean, you know, we could play around. We could have fun imagining what other names, last names, the governor of Massachusetts could have had that would make this a little bit more politically appropriate. But we'll avoid that for right now. Right. So, how is gerrymandering accomplished? All right, it's accomplished by packing and cracking voters. Those are two terms you're going to hear a lot about during the course of this talk today. Right, cracking and packing voters. All right, so, and I'm going to go through a little exercise here to kind of give you an idea what packing and cracking is and how it's done. All right, so I want you to imagine a legislative map composed of 50 precincts, right? Of which 40% are the teal party and 60% are the blue party, and we are charged with creating 5 equally sized legislative districts. So now, there are 30 blue precincts and 20 teal precincts, right? The ones on top, 30, 20, and 30, okay? So now imagine that we, in this room, we are the teal party leadership. And we are very strident, aggressive, and we take no prisoners. We want to annihilate the blue party. We want to hurt them, and we want to permanently install ourselves in power over the course of the entire decennial cycle that this map that we're going to draw is going to be in existence for. All right? How many of you think that those 40% teal guys can obtain a majority of those 5 districts, 3 out of the 2 districts, and do it in a way that they will stay in power no matter what happens in terms of wave elections, you know, and all of that kind of stuff? How many think we could do that? Ha! Okay. All right, yeah. So, well, you just answered that question. All right. So first we do is we crack some of the blue party, the blue districts. We crack 12 of those districts, 12 of those precincts into 3 districts. So in those 3 districts, you have a 60-40 majority of teal party adherents. All right? You can see that? And then we pack the remaining blue party people into 2 districts in which they represent 90% of the voters in those 2 districts. Right? So now, because you know, just think about this for a second. You know, you're not going to see a swing in a wave election that can overcome a 60-40 population matter. You might see 55%, 56%. Maybe in a very egregious circumstance, you might get up to 59%, but 60%, you don't see that kind of a swing in an election. So here we have a situation where the gerrymandered this way, the teal party will control this hypothetical legislative body for as long as the gerrymander stays in place without regard to future swings of voter turnout. All right? And most importantly, the electoral process itself is incapable of correcting this systemic devaluation of the weight of the vote of the blue party members. Incapable. Right? None of those districts are swing districts. The consequence of this is that elections are decided in the primaries, not in the general elections, and the hardcore base of each party controls that primary process, leading to greater and greater polarization. Now, this has been happening in the United States at an ever-increasing rate of speed. Since computer technology has taken us from the days of Elbridge Gerry in 1812 to today. We have very sophisticated computer technology. There are programs called Autobound, for example, that are used to draw these district or maptitude, and they can do this in a way that adheres to traditional redistricting principles. So in the old days, you used to be able to tell if a district was gerrymandered by did it look weird. You know, they'd have legs sticking out over here and a head over there and a long tail down there. You know, those kinds of irregular districts were the hallmark. But today, you rarely see that. Today, you see districts that are compact, they're contiguous, they satisfy all of the major norms that are used in the redistricting process, but they are highly targeted, by these sophisticated programs that are developed. Next slide. This is I borrowed from Nate Silver from 538. But what you see here on the left, if you go back to 1992, you can see that there were 103 swing districts. These are congressional districts in the United States. That means that a swing district, you can see, is defined as a district that can swing either way, right? Because the partisan population within that district is capable of going one way or the other in any given election, right? Every single four-year period after 1992, the number of swing districts, congressional districts in the United States have decreased year after year, from 103 to 85 to 61 to 44. It bumped back up to 55 in 2008, and then it went down to 35 in 2012. It's a lot less now. But you can see the shape. And simultaneously, if you look at the end, so now we have 125, in 2012, we have 125 GOP landslide districts, and we have 117 Democratic landslide districts, right? And a very small number of swing districts. This is another chart. This one is by Charlie, the Cook Political Report. Many of you probably have seen Charlie Cook on TV. And this was published in 2013. The black line is the swing districts, and the red and blue lines are the strongly controlled partisan districts, where there's no possibility of a swing. And you go back to 1998, I think it's, there were 164 swing districts, according to Charlie Cook, and today, as of 2014, there were 90. You see the steep decline right there. And you see the rise in the concentrated districts that are controlled by only one party. This works like a cancer on our electoral system because it increases the political polarization, as I indicated before, by centering races in the primaries rather than general elections. So what happens here is your elected officials pay attention. They pay attention to the hardcore base, which we've all gotten pretty used to hearing about, and they ignore the concerns of moderates and other party adherents. Their voices are silenced in this process. So is partisan gerrymandering unconstitutional? Right? The short answer is probably. Probably. Right? In the Whitford court is the first court to say yes after a full trial that considered a full evidentiary picture of what happened during the redistricting process. You're going to hear about that today. Right? The long answer is shrouded in a series of blurry plurality decisions that give lawyers like me optimism, but also creates a lot of work for political scientists. Now, the thing about how many people here know what a plurality decision is? Oh, fair number. Okay, everybody on this side knows. No one on that side knows. I'll talk to these folks for a minute here. A plurality decision is a decision where a court does not arrive at a majority opinion, a majority holding. So let's take, for example, Brown versus Board of Education. That was a 9-0 decision. Right? There's no plurality. That is the decision. It is the law. Right? There's no ambiguity. Right? We go to Roe v. Wade. That was a 7-2 decision. Again, a majority decision, a holding that has the same force of law as the Brown versus Board of Education, because it was a majority. Lawrence v. Texas, a case that created the rights for gay couples to be intimate with each other. That decision was a 6-3 decision, a majority decision. Right? Citizens United versus FEC, that was a 5-4 decision, but it was still a majority decision. All of those decisions I just read off are the law of the land. They're not, one is not more stronger than the other. They are all majority decisions. But there are a lot of decisions that happen when the court can't come together with a majority. So we'll go into some of those cases right now. We'll start with I should point out that Justice Anthony Kennedy is the linchpin in gerrymandering, as he has been in so many other areas of law. Right? He has joined pluralities and given one side a victory in terms of the decision, but those plurality decisions are not binding law. Right? They're hints about where the court might go in the future, depending on what is written in those opinions. But you can't take binding precedent out of a plurality decision and apply it to a different circumstance. All right? That's in very important context. All right? So the very first time the United States Supreme Court ever even mentioned the word partisan gerrymandering was in 1983 in the case of Karchner versus Daggett. Right? The majority opinion struck down a New Jersey congressional plan entirely on the basis of one person, one vote. Remember earlier I was talking about reapportionment, right? The relative equalness of the populations of the congressional districts. So that's what the Supreme Court did in that case. And the deviation there was 0.7%. Right? Justice John Paul Stevens concurred in that result. He wrote a separate opinion, but he did not adopt the majority opinion. He thought it was a pro-democratic partisan gerrymander, and he wrote that he would have overturned that rule. He would have upheld the challenge to the redistricting plan on that basis in that decision. Now, that was just a mention. So the term partisan gerrymander appeared for the first time in 1983. Right? Now, the very first time the Supreme Court directly addressed partisan gerrymandering was 3 years later in 1986 in the case of Davis v. Vandermeer. A clear majority of the justices, 6 of them, agreed that gerrymandering was not a political question, but rather it was a justiciable controversy under the Equal Protection Clause, and that a plaintiff must prove discriminatory intent and discriminatory effect. Right? Now, that's a majority agreed on that, but but the court splintered, and a majority could not agree on a standard that governed such cases. Right? The plurality held that unconstitutional discrimination occurs only when the electoral system will consistently degrade a group of voters' influence on the political process as a whole. That's a quote from the decision. Right? And the plurality, these are plurality, now this is not a majority, okay? The plurality decided that the Indiana plan in that case did not satisfy that standard, so they found no unconstitutional gerrymander, right? 18 years after Vandermeer, for 18 years, not one single court struck down a redistricting plan on the grounds that it was a partisan gerrymander. Right? And then 18 years later, we get the case of Veith v. Jubileer, 2004. This is a very important case. Right? A plurality of 4 justices. Now, we're talking plurality decisions here, okay? We're not talking about clearly applicable rules of law that can be applied in a given litigational context. So a plurality of 4 justices, Scalia, Rehnquist, Thomas, and O'Connor, held that partisan gerrymandering claims are non-justiciable political questions and therefore are not subject to judicial review. They're saying, you're on your own. You know, even though we know the political process can't fix it, we're going to pretend as justices we don't see it. You know, we're going to bury our head in the sand. We're going to cast you into the political winds knowing that you cannot fix this. Right? Anthony Kennedy emerged as a key vote in this case because he refused to join that plurality and say that this is non-justiciable, that this is a political question. But he concurred in the outcome. He said, I don't agree with your reasoning about this not being justiciable, that this is a political question, but I agree that the law, that redistricting plan, doesn't meet a standard that we can apply. all right? So Kennedy concurred in the result. So the result was that in v. Jubileer, they were unable to prove redistricting, unconstitutional gerrymandering. But Kennedy wrote, and this is important, I put the full quote in because I really like this quote, "A determination that a gerrymander violates the law must rest on something more than the conclusion that political classifications were applied. It must rest instead on a conclusion that classifications, though generally permissible, right, were applied in an invidious manner or in a way unrelated to any legitimate legislative objective." He added that no such standard has emerged in this case, that means the Jubileer case, should not be taken to prove that none will emerge in the future. Now, Justice Scalia was on the other side of that saying, oh, the fact for 18 years nothing came means there cannot be a standard. There is no standard. That's what Scalia said when he wrote the majority, the plurality decision. Kennedy also wrote some other interesting things that I want to draw your attention to. He said, "It is not in our tradition to foreclose the judicial process from the attempt to define standards and remedies where it is alleged that a constitutional right is being burdened or denied. If a state passed now this quote, I lift it because Kennedy went back to this on the oral argument in our case on October 3rd. So that and this is what he said then, and this is back in v. Jubileer. If a state passed an enactment that declared all future apportionment shall be drawn so as to most burden party X's rights to fair and effective representation, though still in accord with one person, one vote principles, we would surely conclude the Constitution had been violated. If that is so, we should admit the possibility remains that a legislature might attempt to reach the same result without that express directive. This possibility suggests that in another case, a standard might emerge." Okay? And I think we hope that that standard emerged in the Whitford case. Finally, Justice Kennedy speculated that the First Amendment might prove more fertile grounds in the search for a judicially manageable standard than the Equal Protection Clause. The theory is, so because whenever you say something's unconstitutional, you have to be able to say why. Why is it unconstitutional, right? I mean, it's like, so, the history here is we approach this with, we presume it to be equal protection, that the Democrats are entitled to equal protection under the law as compared to the Republicans, and that the legislature ought not set up a differential scheme on that classification basis that burdens the Democrats unfairly, right? Equal protection jumps out, right? But there's problems with equal protection theory. It's like trying to put shoes on that your feet don't quite fit in, and when you really, so so Justice Kennedy's been an advocate for First Amendment. She says, well, what you're doing is you're burdening the speech of the political speech, the right of association of Democrats to associate with their party for purposes of political speech in a way that burdens them unfairly as compared to the Republicans. This is an impairment of the First Amendment, is what Kennedy has written about. The most recent decision before my case was 11 years ago in LULAC v. Perry in 2006. And this is the key decision that gives lawyers like me a lot of hope for the future. Again, Justice Kennedy emerged as the key swing vote. Again, the court did not declare the gerrymander unconstitutional. Right? Again, Kennedy concurred in the judgment in the plurality decision. But the court assumed that gerrymanders are justiciable, but the majority concluded that the plaintiffs failed to identify, and this is key language here, a manageable, reliable measure of fairness for determining whether a gerrymander violates the Constitution. Right? Two things are implicit in that sentence. One is, not all gerrymanders violate the Constitution. Right? That's a very important piece. And the other piece is that the measure needs to be manageable, it needs to be reliable, and it needs to be targeted on detecting fairness, promoting fairness. Right? political science professors Bernie Grofman from UC Irvine and Gary King from Harvard, they filed a very important amicus brief in that case with the court, proposing a measure that's called partisan symmetry, right? Which basically, and this was very well received by at least 5 of the justices, including Kennedy, right? But Justice Kennedy opined that he was wary of invalidating that redistricting plan on the grounds of partisan symmetry, because the partisan symmetry mechanics that these 2 political science professors proposed involved using statistical models that operated on hypothetical elections, okay? So Kennedy said that he was wary of invalidating a plan, quote, based on unfair results that would occur in a hypothetical state of affairs. He wanted to see real unfairness in real elections. Okay? Then we had, just a couple years ago, 2015, the latest hint of where the court was on this. In the case of the Arizona State Legislature versus the Arizona Independent Redistricting Commission. Right? The Constitution refers to congressional reapportionment as involving work by the legislature. It actually refers to the legislature in that clause in the Constitution. So some of the Republican legislators in Arizona didn't like the redistricting plan that the Independent Redistricting Commission from that state had generated. So they sued and said, that's unconstitutional. It's unconstitutional. The legislature has to draw the redistricting, as opposed to doing it by a referendum. Because the commission was created by a referendum. And so in that decision, the majority decision, by the way, the Supreme Court found that that was constitutional, that nonpartisan redistricting commissions are perfectly constitutional. There is no constitutional impediment to that model, and most of us really support that idea. It makes a lot of sense. But the first hint, there was a hint here about partisan gerrymandering, because in the very first paragraph of this decision, it was written by Ruth Bader Ginsburg. She wrote the following sentence in the very first paragraph. Here it is. This case concerns an endeavor by Arizona voters to address the problem of partisan gerrymandering. Dash. The drawing of legislative district lines to subordinate adherents of one political party and entrench a rival party in power. Okay? That's what she wrote in the very first paragraph. What's very important here is that Justice Kennedy joined that opinion. Right? So Justice Kennedy is sitting there with a majority of the court, saying, this is my view. He signed on to this decision. Right? Now, your conservatives on the court, Roberts, and so forth, they wrote venomous dissents over this decision. But nevertheless, this is not a plurality decision. This is a majority decision. This actually governs. It has the same force of law as any other majority precedent, binding precedent. Right? Partisan gerrymanders, this court recognized, are incompatible with democratic principles. That was the second part of the sentence, the next sentence that Ruth Bader Ginsburg put in that decision. All right, this Arizona decision came out on June 29, 2015. We filed the Whitford complaint in Wisconsin federal court in the Western District of Wisconsin, Madison, Wisconsin, on July 8, 2015. Just, literally a week later. Right? So, what is partisan symmetry? All right? Partisan symmetry is a way of measuring partisan fairness. Right? According to Professors King and Grofman, quote, the symmetry standard requires that the electoral system treat similarly situated parties equally, so that each receives the same fraction of legislative seats for a particular vote percentage as the other party would receive if it had received the same percentage of the vote. So if 59% of the voters vote for Republicans, and they would get a certain number of seats as a result of that 59% statewide. If 59% of the voters went Democratic, the Democrats ought to get the same number of seats. Right? You can't have a situation where the Republicans, well, let's give you a hypothetical similar to Wisconsin. Republicans get like 40, let's say 48% of the vote, all right? But they get 60% of the seats, right? So you ask the question, well, if the Democrats get 48% of the vote, do they get 60% of the seats? No, right? There's not symmetry there. It is the lack of unfairness on how the parties are treated with regards to their ability to convert votes to seats. That is the gravamen of gerrymandering. All right, let's go back to the packing and cracking of the blue party in order to rig elections in favor of the teal party, right? Here we go. All right, you got the cracked seats on the left and the packed seats on the right. As a result of this scheme, the teal party wastes 47 votes, right? Whereas the blue party wastes 198. Right? Now, what do I mean by wasted votes? Right? When I'm talking about wasted votes. So if every vote over 50% plus 1 for a party is a wasted vote, that means it's a vote that doesn't affect the outcome of the election. Right? Every vote on the losing side, is a wasted vote because it doesn't affect the outcome of the election. Right? So you add the excess votes above 51 and all the votes of all the losers together for one party, and you divide that by the number of total votes in the election, and you can get a comparison of the efficiency with which the two parties are able to convert votes to seats. The teal party is able to convert votes to seats very efficiently. The blue party converts votes to seats very inefficiently. It wastes lots of votes. Right? So this is what we call the efficiency gap. Right? It is a measure of partisan symmetry that does not depend on hypothetical, statistically modeled elections. The efficiency gap represents the difference between the parties' respective wasted votes in an election divided by the total number of votes cast. It captures in a single tidy number all the cracking and all the packing decisions that go into a redistricting plan. It isn't hypothetical, as tests of partisan bias had been in the past. And here we have the same chart showing that. Now let's do the math here. You can see the math. Calculating the efficiency gap. This is a simple mathematical equation that any high school math student could do, maybe even a junior high school math student. The efficiency gap equals the total teal wasted votes minus the total blue wasted votes divided by the total votes. 47 teal votes minus 198 blue votes equals minus 151 divided by 500 equals 32.2%. Right? This means that an efficiency gap of 32%, this is what it means. It means that the teal party is getting 30.2% more seats than we would expect if it had participated in an election under a neutral redistricting plan that didn't favor either party. They feathered their nest with a 30% bonus, all right? An insurmountable bonus, right? So, all right, that's background. Now we're going to get into the story of Wisconsin. Maybe Jane will give me a signal for time for questions, all right? So, okay. Is that all? Oh, my goodness, okay. All right, so something happened in 2010. I'm going to speed up really fast here. There's a book. I don't know if I'm allowed to say the name of the book. It's Rat, F-U-C-K-E-D. Okay, and that is an actual term that is used in politics for playing dirty tricks on the other side. This book is available in the public libraries here. I know it's available at Blaine, Point Roberts, and Fairhaven branches of the library. This term is, it's, like I said, it's a term for dirty tricks, but it describes a project called Project RedMap. Right? How many people have heard of Project RedMap? Oh, good. Okay, some people have. All right, good. And this is a highly surgical project that was in advance of the 2010 decennial elections. So because this guy, his name was Chris Jankowski. He took $1.1 million and targeted, that's not, consider this nationally now, all right? $1.1 million. It's peanuts when you're considering a strategy to take over the United States electoral system, right? But he targeted very surgically at certain legislative districts in a handful of states: Pennsylvania, Michigan, Ohio, Wisconsin, North Carolina, Virginia. He targeted those states with an idea of taking over, getting a clear majority in both houses of the legislature in those states. Those states all had something else in common. They had Republican governors, and they would have complete uniform control for the redistricting process, right? And they, just by pure happenstance, of very unfortunate happenstance of history, that targeted investment occurred or converged with one of the biggest political waves we've seen in many, many years in the United States. The 2010 election was a massive Republican wave. So he had success beyond his wildest dreams. And as a result, the Republicans took complete control of government in Wisconsin, and just in time for the 2011 redistricting process. They undertook a very aggressive legislative agenda. What happened here was they moved the redistricting process out of the state legislature. The Wisconsin Constitution has a provision that says all legislation has to be done behind an open door. The courts have interpreted that to mean that legislation needs to be done in public. People get to see how the sausage is made, right? People get to know what is going on, what the negotiations are, and they get to witness the committee, the drafting process, and so forth. This is the people's business, right? Well, in Wisconsin, what they did was they took the computers and they moved them to a private law firm. Here we go. Right? That's the Capitol. And the law firm is Michael Best and Friedrich, a very large law firm, hundreds and hundreds of lawyers. That's Brent Previs was a partner at Michael Best and Friedrich. And one of his right-hand men, a guy named Eric McLeod, was in charge of the redistricting process. They created a war room, a secret redistricting room, that no one was allowed to enter. They had 3 computers, and no one was allowed to see the whole map, not even the Republicans. Republicans had to sign secrecy pledges. This is a copy of one of the secrecy pledges. And the secrecy pledge said that everything that they saw when they went into that room to look at, and they were only allowed to see their own district. They weren't allowed to see the whole map, only their own legislative district. And they were only told about the projected political performance of that district. Right? And so that document contains a bogus assertion of attorney-client privilege and work product protection over the entire content of the conversation between that legislator and the people showing him his legislative district. Every single Republican legislator signed one of those secrecy agreements. They wanted to keep those secrecy agreements secret. So when they disclosed this map, the first thing I saw was that they were discriminating against the Latinos in Milwaukee County, in the city of Milwaukee, in the 8th and 9th Assembly districts. And I said, this is naked vote dilution against Latinos, and it violates the Voting Rights Act. It violates Section 2 of the Voting Rights Act. I filed a lawsuit. Right? And I immediately asked, I want every document that was generated in the course of redistricting. I want to see everything. And they said, no, attorney-client privilege, work product, you can't see any of it. I said, well, I'm subpoenaing it. You got to give them to me. And they moved to quash the subpoena. And the court ruled against them and said, no, you got to give them the documents. Right? And they moved for reconsideration. The court said, no, stop fooling around. Give them the documents. They then moved for reconsideration a third time, and the court got really pissed off. I mean, really, really pissed off. Fined them $17,000 and said, immediately, forthwith, produce all the documents. Right? And it was unbelievable obstruction of justice that was going on. It was naked. It was horrible. But I took those boxes home, all these boxes of documents. I brought them into our TV room. I sat down and I started going through them, and I could not believe what I saw. I mean, for starters, we had the secrecy agreement. We had all sorts of memos and memorandum. We saw the most sophisticated analysis this is a chart. They've hired a professor from the University of Oklahoma named Ronald Gaddy, who's actually a wonderful man, but who developed for them a statistical model for how to project political performance based on past electoral history, broken down to a census tract level. He developed a very elaborate multivariate regression analysis that produced these kinds of tables. And we were able to, but we got those as PDFs. We didn't get them in their native format, right? And so we weren't able to really piece it all together. But then, so this is what happened. We went ahead and had the trial, and we won. We got the Latino districts fixed under the Voting Rights Act. But then we discovered that there were emails that didn't match in what they had produced in response to the judge's order to produce everything. We noticed that the list of recipients didn't correspond to the, there was, some people withheld emails. So we said, Judge, we don't like this. We want to reopen discovery, post-judgment discovery, to explore whether there's been spoliation, whether there's been destruction of evidence, and whether the court has complied, the Republicans have complied with the court's order to compel production of those documents. And the court said, fine, yeah, go ahead, open it up. So we went, and the more we dug, the worse it looked. So we went back to the court and we said, Judge, we think we have, we hired this guy who was the head of cybersecurity for the FBI at one point in the Secret Service, and we said, we need the computers that they used, because this is ridiculous. They are not being straight with us, and they're not being straight with the court. And at first they said, we don't know where the computers are. And we said, well, then we're going to do some depositions about where those computers are. And we did some of those. We found the computers. And we said, okay, now we want the hard drives. And they said, you can't have the hard drives. So I said, Judge, could we get the hard drives? And the judge said, absolutely, you can have the hard drives. So we had those hard drives imaged. And what we found was a whole series of documents that are, it's a form of sensitivity testing, if you will. What it is this is a very elaborate chart that shows how a particular legislative district would perform based on how many adherents of a party vote. Okay? It's the X in the middle, the two lines crossing in the very middle. Right? That assumes a 50-50 election. Okay? And then every single column going up and down is a 1% increase or decrease, depending on which way you go, of the votes for one party versus the other. So as you go to the left, you get an increase in Democratic votes. As you go to the right, you get an increase in the Republican votes. But it shows you how they very carefully planned to be able to maintain a majority in the legislature, regardless of whether they had a majority vote or not. They went back into history and they said, what was the single largest Democratic swing since 1972? Right? And they took that number, it was 56%, and then they calculated the remap so as to be able to survive in the legislature, even if the Democrats got 56% of the vote. They would still maintain a majority in the vote. It's absolutely incredible. This is the drafting sequence. There's 99 legislative seats in Wisconsin. Okay? It's and with each iteration of the map that they drew, this is what we got from the computers. They increased the number of seats they would get based on a 50% turnout for Republicans. So you can see that they went up to 59 seats based on a 50% turnout in the election. These are their documents, right? These are their documents. Here you see Milwaukee. The area on the top there is the Milwaukee suburbs. The city of Milwaukee is cut out, right? But you can see that in the beginning, there were 4 Democratic seats and 4 Republican seats in the suburbs around the city of Milwaukee, right? After the redistricting, they carved those up so that there were 6 Republican seats and 2 Democratic seats. And that's an example of how they did it there. Down below you see Racine and Kenosha, where you had 4 Democratic seats and 2 Republican seats before. Afterwards, you had 3 and 3. You know, they just cut and pasted the votes in order to get it done. So what we did was we developed a theory. We said, look, we can prove intent off of their documents. Right? They themselves declare their own intent. Right? We can prove effect, the unconstitutional effect of burdening the other side off of their documents. They did the work themselves. They developed the regression analysis. We went out and hired some really good experts ourselves to double check that, and they were right. They were very, very accurate. We actually went, this is a chart put together by a political science professor from Stanford named Simon Jackman. He's one of the most highly renowned political science professors in the world that studies electoral conduct. Every single lateral line, horizontal line you see there, represents a redistricting plan going back to 1972. Every redistricting plan, legislative redistricting plan, in every single state in the entire United States from 1972 to 2012 is on that chart there. And what you can see back in the old days, in the 70s, you had a lot of gerrymandering being done by Democrats, right? That's when we still had Dixiecrats, right? And, but over time, it switched over to mostly Republican gerrymanders, you know? And the efficiency of those gerrymanders got worse and worse and worse. So the worst gerrymander, the 4th worst gerrymander since 1972 is right there, and that is the Wisconsin gerrymander that we prosecuted in court. So that's basically what happened. I'm going to just say a few words about where I think we're going with this situation. At the oral argument, by the way, the lawyer who argued for our team was a fellow by the name of Paul Smith. He's argued 17 cases at the United States Supreme Court, 18, including our case. And he also argued Lawrence v. Texas. I mean, this is, and Veith v. Jubileer. He's a real pro, fabulous lawyer. And there was an interchange between him and Justice Roberts. I won't read it because of time. We're going to get to the questions. But well, basically what Justice Roberts did during the oral argument was he said, this is his major objection. He said, Mr. Smith, if the court takes this, rules on the merits and rules in favor of you, then people will think that we favor the Democrats. If we rule against you, people will think we favor the Republicans. You know, this is a quagmire for the court to get involved in these kinds of things because it will threaten the integrity of the court. Right? We don't want the court to be seen as having a partisan interest. You know, that's what you know, Justice Kennedy said. Justice Roberts said. Yeah, exactly, exactly. So now Paul Smith said to him when he said this, if you let this go, if you say we're going to have a judicial remedy for this, we are not going to have a judicial remedy for this problem, in 2020, you're going to see a festival of copycat gerrymanders, the likes of which this country has never seen. And it may be that you can protect the court from seeming political, but the country is going to lose faith in democracy. Now there was an interesting, my last point real quick. There was a very interesting development that happened because right before our argument, there was a case in Maryland, right, in which Republicans were challenging a Democratic gerrymander of a congressional district. Right? And they moved for a preliminary injunction, got denied. They went to the Supreme Court and said, hear this case. The Supreme Court, and they asked for expedited review. The Supreme Court tabled it and said, we're going to decide the Whitford case. We'll talk to you later about it, right? And then Roberts made his comments, you know, and attorney Paul Smith made his comments, and then sua sponte means on their own, the Supreme Court decided to hear the Maryland case. Probably it's going to be heard in March. They're going to hear it this term. So I take that to mean that we're looking at potentially a 6-3 decision instead of a 5-4 decision, that maybe this is being done in deference to Justice Roberts' concern so that the court can decide a Republican gerrymander at the same time it decides a Democratic gerrymander, and thereby avoid being seen as partisan and threatening the integrity of the court. Now, that gives me optimism, all right? I'm always looking for the optimistic angle here. Now, but if I'm wrong, and this court says this is all okay, and it's not unconstitutional, we got to put that in context. It's not just that gerrymandering becomes constitutional, but gerrymandering becomes constitutional at a time when every single voter suppression legislation that has gone through the courts is accepted as okay. Okay? We will be able to have fewer registration hours, we'll be able to have voter purges, we'll be able to have voter ID laws that are ridiculously burdensome, we'll be able, combined with gerrymandering, so you suppress the vote, you gerrymander the vote, and then you inject dark money through Citizens United. Right? I'll leave you with this analogy. All right? We all have bodies. And when we're sick, perhaps we have an immunological disease, and our immune system turns in on itself and begins to attack our body, and we get very, very impaired. If we don't go to the hospital, if we don't take care of that, it becomes an existential threat to our body. Right? Democracy, representative democracy in the United States is in exactly that position today. We are sick, very, very sick. If we don't get to a hospital real soon, our representative democracy could die.
Not bad.